So is she contesting at this point the removal?
No, Your Honor.
All right, thank you for those pieces of information. That does answer nearly all, in fact, the questions under 3.965 governing our proceedings on a preliminary hearing. Deputy Ames, would you swear in Ms. Bobby McGee for us, please?
Please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Ms. McGee, do you have a copy of the petition that was filed yesterday?
Yes, I do. It's in my email, but yes, I do have it.
Good. And is everything that Mr. McFarland just shared with us accurate?
Yes, ma'am.
All right, thank you. Very good. Any position on the request to enter no contest plea?
I have no position. I have no objection.
Very good. Ms. Heiss, would you find it to be in the best interest of this child for me to receive the plea?
Yes, Your Honor.
Okay, well, Ms. McGee, then I'm going to go over your rights with you and as part of that process. If I accept your plea, you are giving up a right to a trial by judge or trial by jury. The right to have the petitioner prove the allegations in the petition by a preponderance of the evidence. The right to have witnesses against you appear and testify under oath. The right to cross-examine witnesses and the right to have the court subpoena any witnesses that you believe could give testimony in your favor. You would always have your attorney, you have a right to an attorney at each and every hearing as well. So Mr. McBrown would certainly be there to help you with all of those things at any trial. Do you understand you'd be giving up or waiving your trial rights that I've just went over if you enter a no contest plea?
Yes, ma'am.
All right, as it relates to a no contest plea, essentially what that means is without you saying anything, I will effectively assume that the allegations in the petition are correct and look at whether or not those violate the statute and require the court to intervene. Do you understand that?
Yes, ma'am.
All right. With regard to the consequences of that plea, or in other words, what will happen, the court will do the following. There will be continued investigation by the caseworker to see what the problems are in your family and how and whether they can be solved. The court could dismiss the case if there's no need for the court to be involved. If it appears that there's a problem that may be solved, the court can make the children or the child a temporary ward of the court, place with mother or father or with relatives or in a foster home, and order programs for you and your child, such as counseling, drug and alcohol treatment assessments, or parenting classes. If it appears you will not be able to provide a proper home for the child in the reasonably foreseeable future, the court could terminate your parental rights. In regard to the plea itself, plea can also later be used as evidence in a proceeding to terminate your parental rights. Do you understand the consequences of your plea, Ms. McGee?
Yes, ma'am.
Do you have any questions about any of the information I've given you so far?
No, ma'am.
Is anyone making you enter a no contest plea?
No, ma'am.
Has anyone threatened you in any way to get you to enter that no contest plea?
No, ma'am.
Do you feel that you are under the influence of anything that could get in the way of you understanding what you're doing right now, like any drugs that you might be on through the hospital or anything else?
No, ma'am.
Has anyone promised you anything in order to get you to enter a no contest plea?
No, ma'am.
Would you say that your decision to enter a no contest plea is one you've made of your own free will?
Yes, ma'am.
Or Ms. Thomas, at this point, look for you to establish the factual basis for the plea, please.
Thank you, Your Honor. If Ms. Harvey can be sworn in, please.
Ms. Harvey, come on up to our witness stand.
You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Before we get into that, I don't think we did this on the record. I know we discussed it just briefly by sidebar before we began, but the reason for the no contest plea, Mr. McFarland?
We did put this on the record. I said fetal neglect, Your Honor.
Okay,
Which would be a crime.
and that is based on,
The child or the mother testing positive multiple times, including just days ago, for controlled substances.
thank you. All right, very good. Go ahead.
Thank you. Ms. Harvey, can you state your role in this matter?
I'm the CPS investigator.
Thank you. And as the investigator, were you able to establish that the child, I'm sorry, back up. As a CPS investigator, can you explain your process and how you formulated the allegations that are contained in the petition.
Yes. We received a referral that MS had been born, and that at the time of birth, mother did not test positive for any substances. However, there was an indication that she has come in foster care, and during that foster care case previously, she had tested positive. So I went over the testimony from the previous investigation and received a copy of the court report from the from the foster care worker, which did show two positive tests for methamphetamine in the third trimester. The court results from MS are still pending. Currently, nurses indicate that there are no withdrawal symptoms, but we're still waiting for those results. They're trying to hurry those along as fast as they can. But we did have the 2 positive results on record.
Okay. And were you able to speak with Ms. McGee in this matter?
Yes, I did. I spoke with her yesterday.
Okay. And had she admitted to any use within the last?
Yes, she indicates that her last day of use of methamphetamines was January 28th.
And the current home that Ms. McGee is living in, is that appropriate for the child to be sent home to?
Fostering Solutions did the placement assessments on that home, and they indicated that due to safety concerns in the home, it was not appropriate.
And you mentioned that there's already another child in care that was born to these parents, correct?
That's correct.
And the reason that child was removed, do you recall the reason the child was removed?
I believe it was substance use and domestic violence and housing instability.
From review of the court report, were you able to determine whether the parents had complied with and benefited from their current case service plans?
I believe it indicated that there was a lack of compliance and minimal benefit at this time.
And were you able to speak with Mr. Stage in the last couple of days?
No, I have not been able to speak with him yet.
And to the best of your knowledge, he remains incarcerated?
Yes.
One of the questions that will likely be asked is the placement plan. The petition asks for the court to place the child with the Department for Care and Supervision. Do you happen to know what the placement plan for this child would be if the court?
Yes, the current placement would be in the same licensed foster care home as the older child, SS.
The testimony becomes even more serious. The investigator explains that multiple positive test results were documented during pregnancy.
And are you aware of any sibling visits that have already occurred?
Yes, there have been 2 sibling visits already that have occurred this week.
Is there anything else that you would like to state for the record to help the judge and make her findings?
No, just that it seems that the same issues that brought SS into care are still evident today.
As it relates to reasonable efforts, I know that there's a lot of citing back to the foster care case. Were you able to offer any additional services since your investigation?
Yes, we spoke about services. I kind of wanted to get a plan for her case service plan and how she felt about it and what she was looking forward to. And we did talk about the substance use, as that is my main concern in this case. I offered to assist her with inpatient. She doesn't feel that inpatient substance use treatment is appropriate for her at this time. She's afraid that it will impact her employment, and she's only interested in outpatient right now.
Thank you. Your Honor, I have no further questions for Ms. Harvey regarding the factual basis of the plea. Questions?
I do. My understanding is that we do not have the umbilical cord results yet, correct?
That is correct.
We don't have any doctor's reports indicating that the child is born addicted or that there's any consequences of mother allegedly using controlled substances to the child, correct?
As of today, that's correct. They're still monitoring as the child and the mom have not been discharged yet.
Okay. So do you know the particulars as to why the home, I believe it's her parents' home, correct?
Yes.
why that is not an acceptable placement.
I don't know, I myself don't know the particulars on it. I didn't do the assessment. The fostering solutions foster care worker would have more details on the specifics for
So
that.
you're not going to be the ongoing worker, correct?
That's correct.
Because what happens if the results, the umbilical cord results turn out to be negative and there is no negative side effects to the child from my client's possible addiction?
Then we go back to look at the reasons that SS would be in care, which would be housing instability and the domestic violence. Until very recently, there was no contact order between the two parents that was continuing to be broken. So that would still indicate an issue there. And we still have the housing, but that assessments have indicated is not appropriate. While she is looking for housing, she has not gotten any yet.
Thank you. Nothing further.
Ms. Heiss,
I have no questions. Thank you.
any redirect?
No, Your Honor.
All right, thank you for your testimony. May I return to your seat? Any other witnesses?
No, Your Honor. Your Honor, just as it relates to placement, if Ms. Brinker can respond in, please. Thank you.
Christy Brinker?
Thank you, Your Honor. Please raise your right hand, Ms. Brinker. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Good morning, Ms. Brinker.
Good morning.
Can you please state your role in this matter?
I am the foster care worker for the older child in care.
And will you be, if the court removes the child, will you be the foster care worker for this child as well?
I will, yes.
Okay. And it sounds like the plan currently is for this child to be placed with the older child in a licensed foster home?
Correct.
Okay. Can you briefly, I'm sorry, have you had the opportunity to explore potential relative placement for that older child?
Our agency did do relative searches, and all of the relatives that were given at the onset of the case have all been denied for various safety concerns, whether it be criminal history and or safety concerns in the home. All of the relatives have received a denial letter at this point with the opportunity of things that needed to be corrected. And we have not heard back for any reassessment from any of those relatives.
Does that include Ms. McGee's parents?
It does, yes.
And, okay. And so you have not reviewed that home recently, is that correct?
Correct.
Okay. Thank you. Your Honor, I have no further questions for Ms. Brinker.
So would you review Ms. McGee's mother's home to, and she would like you to do that?
Yes, I mean, if Mrs. McGee's mother would like us to come out and reassess her home, we would absolutely welcome that.
Okay, so the denial letter is from an earlier placement request, not for a placement request right now, correct?
Correct. I believe that they probably just received that within the last 30 days though. So they're aware, they were verbally told and then they received written list.
Because I don't have access to that denial letter. Can you tell me the particular criminality concerns?
I actually do not have that in front of me, and being there was other family members, I can't really speak to that at this time.
So we don't know that that house is not acceptable if we don't have that denial letter, right?
I just don't have the denial letter, the particulars in front of me because our licensing department handled that denial. I do know that there was still pending CPS charges from Texas that we were still waiting to obtain. I believe Miss McGee's mother was requested to obtain that, and we haven't received those.
Do you happen to know any of the physical barriers in the house just offhand?
I believe there was not suitable beds. And I honestly, I don't want to speak to it because I don't want to get them all confused. I believe one of the homes had a wood burning stove and there was no area for the older child and to walk around as she was just learning to explore. I understand it's a little different for a newborn, but I believe there was not appropriate sleeping arrangements.
Okay, so it sounds like we'd have to do another inspection of the house then, correct?
We can absolutely do that, sure.
Okay, no more questions, Your Honor.
Ms. Brinker, in your work with the older child, SS, we've had a psychological evaluation of this mother, isn't that right?
Correct, yes.
And her abuse scale was significantly elevated back in July, is that right?
Yes.
And do you think she has partaken in services and benefited from services to the extent that we can say that that abuse scale has been reduced?
She has not.
Attention shifts to placement options. A foster care worker explains that relatives were previously evaluated, but denied for various safety concerns.
She engaged initially and engaged with the McCullough and Vargas for about a month and then discontinued services, and that is when she relapsed. She re-engaged right at the last court hearing. And then I actually just checked in with her counselor just to touch base again to make sure that we had the psych eval and that all the appropriate services were going to be in place so that we can get them reunified. And she states that she has not heard from Ms. McGee since February 5th. She knew that she had court that day and wasn't sure what was going to happen due to the show cause due to her positive drug screen. So that's 10 days that she did not have contact with her counselor or peer coach. So there are definite concerns about her ability to follow through with the outpatient treatment at this time.
Thank you. I have nothing further.
You redirect?
No, Your Honor.
One follow-up question, Your Honor. Do you think that your case service plan for this newborn child is going to be any different than the existing case service plan? For example, would you like a family team meeting to explore that?
I mean, we always welcome family team meetings.
Thank you. Nothing further.
Right. Anyone else you'd like us to hear from?
No, Your Honor.
Mr. McFarland?
As far as the paternity issue, on that issue only, I'd like to question my client, Your Honor, and the ICWA issue.
Go ahead.
Those
She
two.
has been sworn.
Bonnie, if you could unmute yourself. I know we had a discussion. I asked you, do you have any Native American heritage, Indian blood on your family or the possible father's family that you're aware of?
Nope.
Okay, and do you know who you believe the father to be?
Yes.
Who would that be?
Skylar Stage.
Is there any possibility it might be somebody else?
Nope.
And if you are approached with an affidavit, an acknowledgement of paternity, would you sign it indicating that he's the father? Or
Yes.
What's your position? Thank you. And I guess if I can just ask one question on placement, Your Honor. Thank you. Do you prefer your child to be placed, the newborn to be placed with your mother, or would you rather the newborn be placed with its other sibling right now for bonding? What are your thoughts?
Honestly, with her sister, like her to be placed with her sister.
Thank you. Then I withdraw any concerns I have with family placement, Your Honor. Nothing further.
Did you have any questions for this witness, Ms. Thomas?
I do not, thank you.
Ms. Heiss?
I have no question. One quick question. You are bottle feeding this child formula, is that correct?
Correct.
Thank you. I have nothing further.
You look like you might have another question.
Well, maybe another witness. I'd like to call Ms. Brinker regarding parenting time. I think she'd be the person that'd be appropriate to ask that.
Very good. Go ahead. She is also under oath.
Ms. Brinker, with a newborn child like this, you would agree that the mother-child bond is especially important, correct?
Yes.
What would you propose or suggest for parenting time for my client and the newborn?
Well, the minimum is 3 times a week. I do believe we have that already set up with the older child at this point, with the supervised visitation and then 2 additional visits. Also, I am a little, I'm concerned about Miss McGee, and I think that the removal could potentially be another trigger for her. So I'm absolutely willing to go above and beyond on this and get her visitation as much as we can possibly schedule.
So if she demonstrates a history of sobriety from drugs, I presume you'd be testing her, correct?
Yes,
Would you consider expanding that if there's no safety concerns then?
absolutely.
Nothing further.
Any more questions for any other witnesses?
No, Your Honor.
Comments?
No, Your Honor.
Mr. McCrum?
No, Your Honor.
Ms. Heise?
No comments, thank you.
All right, well, the court finds all parties were given notice for purposes of today's preliminary hearing and request for removal. I do find that at this time, with the issues with where Ms. Bonnie McGee is staying, that the safest and least restrictive placement for this new child is in fact under the discretion of the Department of Health and Human Services, which I believe is also the plan is to place this child with the sibling. Obviously, there are benefits to that. This is a situation where mom's housing is not appropriate for the child. She also has some services that she needs to continue. She needs to follow those recommendations to address the things that were raised in the psychological evaluation. She needs to do some parenting education around how those issues could affect her ability to parent a child safely. I do want to recognize, and I don't know that we have any drug test results right now, but I do want to say that I did ask Ms. McGee to stop using methamphetamine as soon as possible under threat of incarceration, but I know that it's a difficult thing to struggle with addiction. And I just want to say that I'm glad to see that she was able to refrain from using at least from January 26th until the child was born, and that the child is not showing any signs of withdrawal. So I know this is a difficult hearing, and I am removing this child, but I want to take a moment to recognize that Ms. McGee was able to at least make that progress since January 26th. So congratulations to you on that. That will certainly influence the court moving forward as far as what kind of parenting time. I would encourage the department to have a family team meeting on that and set up as much frequent parenting time as could be organized between this mother and child. But I do find, as it relates to the petition, that there is a violation of the statute as it relates to provision specifically around the care and maintenance of the child, the necessary medical and care necessary for the child's health, in that the use of methamphetamine during the pregnancy has subjected the child to a substantial risk of harm to the physical health of the child. I also find that the housing and the unremedied issues that were visited on the record contribute to support of the violation of that provision by probable cause. And secondly, if those same facts and circumstances support that there's been a violation of the statute MCL 712A.2B, I think this is for around the home or environment of the child, if I were to place with mom. The putative father is, of course, Mr. Skylar Stage.
Everything now comes down to the judge's ruling. After reviewing testimony, reports, and placement recommendations, the court concludes that removal is currently necessary.
Next hearing, which would be the disposition, I will also set a putative father hearing. Mr. Brooks has joined us by Zoom, so I'll make some time after this for him to talk with his client about steps to be taken on that point. But we'll look at that issue when we come back for disposition. As it relates to removal, okay, so yes, the plea, back to that for a moment, sort of jumping around, I apologize. The plea was knowingly, understandably, and voluntarily made with full understanding of the consequences. I have already found that the record supports that 2 of the pieces of the statute that are applicable have been violated, so jurisdiction over this parent is appropriate, and I am accepting her plea and will take jurisdiction over her for purposes of looking at whether or not she was able to make more progress on her case services plan between now and when we come back in the name of reunification with her and her child. In the meantime, I am ordering the placement of the child into foster care under the Supervision, obviously, of the Department of Health and Human Services through the agency Fostering Solutions and specifically Ms. Christy Brinker at the moment. For the same reasons that the court took jurisdiction over Ms. McGee, I find that custody of the child with this parent does present a substantial risk of harm to the child's life, physical health, and mental well-being. Find further, for the same reasons, that no provision of service or other arrangement except removal is reasonably available to adequately safeguard the child from risks as described above, or before, I should say, that also support 2A. And just for the record, I'm under MCR 3.965C2. On 2C, continuing the child's residence in the home is contrary to the child's welfare for the same reasons. And D, I do find that reasonable efforts were made to prevent or eliminate the need for removal. And those were also explored on record through our caseworker. E, conditions of child custody away from the parent are adequate to safeguard the child's health and welfare. The child will be joining a sibling in a safe home where she will be able to visit as well as visit with parents. Okay. We've already visited the contrary to the welfare of the child factors and the reasonable efforts factors. All right. For purposes of initial disposition and the putative father hearing, let's see. We just had a regular review on this case. Our next review is not scheduled until April 9th, 2024. So rather than waiting that long to look at the disposition on the the supplemental petition, I could offer you some time in front of the referee, if you like, for the initial disposition and putative father hearing.
No objection.
No objection.
Yeah, no objection.
All right. That would allow me to set that then for somewhere in the week of February 26th through March 1st. Is anybody out during that week that we need to be aware of?
Not here.
No, you're not.
All right. How about Wednesday, the afternoon of the 28th at 1:30? And that will be for the, again, for the putative father hearing, as well as the initial disposition on supplemental petition. And then, of course, after that, and we'll communicate this with the referee, the regular review should be scheduled with the already previously scheduled regular review. Any questions?
No.
No. Okay. Thank you very much, everyone, for joining us at such a last.
In addition to the waiver and estoppel theory and the time for erroneous ad liberty theory, it's also a violation of Mr. Warner's constitutional rights, both under the United States Constitution and the Michigan Constitution, to reincarcerate him at this point that he's been let free after serving a portion of his sentence after the court found that he was in contempt of court. More specifically, it would be a violation of Michigan Constitution, Article 1, Section 16, and the 8th Amendment of the United States Constitution, which both of which prohibit cruel and unusual punishments. And under the Michigan Constitution, it's cruel or unusual punishments. The federal Constitution is and. The idea of reincarcerating Dale is abhorrent, quite frankly. And if not shocking to the conscience, I don't know what is. There's nothing more cruel or unusual than releasing an inmate, then waiting 2 weeks after he reintegrates with his minor child, and then saying he's got to go back because somebody at the jail messed up. So that would certainly be unusual. I'm sure nobody in this room has heard of that. And my 15 years of practice, I've never seen or heard of anything like that. So because of the fact that it's unusual, it's unconstitutional under the Michigan Constitution. And it's also cruel and unusual under the federal Constitution. There have been some courts that have opined on that issue. For example, O'Brien versus Saginaw County, 437 F sub 582 out of the Eastern District of Michigan from 1977. The court said in determining whether the conditions of confinement of convicted persons constitute cruel and unusual punishment, the courts have increasingly viewed
The message is clear. Reunification remains possible, but meaningful progress, stability, and compliance must come first.
the effect of the incarceration on the individual. So the prison conditions should not threaten a person's sanity, physical or mental health. And certainly releasing somebody from jail and then requiring them to go back after a period of time would certainly affect their sanity. So for all of those reasons, in addition, Your Honor, once there's been a valid sentence, the court cannot amend a valid sentence once it has started to be served. The court simply just doesn't have that ability. And that is under a court rule. And that is, I believe, that is MCR 6.429. The court may not modify a valid sentence after it has been imposed, except as provided by law. And again, there's no law that permits the court to amend its sentence or to reincarcerate Mr. Warner after he's been released from jail. Additionally, the credit for time served is determined by the jail. I'm not sure of a specific statute or court rule that has a uniform rule. I know that different jails have different credits that are applied for good time. And that's an issue that was that's in play here. And finally, MCR 7.208 provides that once a claim of appeal has been filed, the trial court may not amend or set aside the judgment or order appealed from. So there cannot be any amendment to the sentence at this juncture. So aside from the fact that these proceedings are stayed, the court does not have the ability to reincarcerate Mr. Warner at this juncture. And we would ask for a ruling on our motion for a stay pending the outcome of the claim of appeal that we filed, so that we can get that ruling and we can present it. And if it's denied, we can move the Court of Appeals for a stay pending appeal. Thank you.
Thank you. Mr. Folderman, would you like to be heard on this issue?
Yes, Your Honor. A number of things. One is the Court of Appeals
okay.
has jurisdiction upon.
Hey, Mr. Folderman, it's very difficult to understand you. You're breaking up a little bit. So I don't know if you could, hopefully you're safely pulled over and not actually moving at this moment. I think we'll have to ask you to. It's muffled. We'll come back to you in a few minutes then, once you've been able to find a safe place that you could maybe stop for a few minutes. Mr. McFarland?
I'll be at the courthouse in 5 minutes.
Your Honor, this is not an amendment of a sentence. This is actually carrying out a sentence that was given by this court. These sites that I've heard, I haven't heard any site that's a Michigan site. I could be wrong, but these seem to be federal sites, federal court. They could be used for persuasion, but we're not mandated to follow those. So by this reasoning, if you have somebody, I'm not saying this is this case, but if you have somebody convicted of murder and they are released, I find it hard to believe that Court of Appeals or Michigan Supreme Court is going to say this person is out free, that their time has been served. It's cruel and unusual punishment. When given a life sentence, they don't expect anything. They should expect to be released sooner. Dale Warner likewise was given a some certain sentence, Your Honor. There was a certain amount, there was a certain time. He had counsel. It was quite clear. We don't have any transcripts to indicate to the contrary that the court was ambiguous. Matter of fact, it was very clear. Does Mr. Warner have a responsibility, or at least an ability to say, I understand I was in court, I shouldn't be released as early? That's a question. None of these cases that were cited, although I don't have copies, they haven't been right with me, but I don't believe that any of these cases deal with the jail's policy on releasing early or not. I think it was just a miscalculation. This is not a new or an amendment. This is an existing order. I think the court had the ability to issue a bench warrant as soon as it discovered that. So this is not something new. We're not halting something. There's already an order. He spends the time in jail. Probably could be clarified by a bench warrant, but the court is allowing counsel to order. I do not believe it's stayed by the appellate process, Your Honor. And that's my position.
Ms. Berger. Yes, thank you, Your Honor. I am in agreement with Mr. McFarland on this point. I also do not believe that these proceedings are particularly stayed. I've reviewed the court rules and I can't find anything that exactly pinpoints to this type of ruling that's been made in the past in a probate proceeding. And in that regard, I defer to the court. In relation to the issue of the 8 days that were.
The courtroom grows more intense. Attorneys describe the emotional impact of returning someone to custody after freedom has already been restored.
Not served by Mr. Warner. I think that it's very relevant and very pertinent to know that, by my opinion, which will be evidenced by pleadings that will be filed in this court very soon, that Mr. Warner has continually been in violation of this court's order while he was erroneously released. I do not have those ready to be filed today. Otherwise, they would have been presented to you before today. However, there are several incidences where he is attempting to operate business through the farm, where he is directing others to violate the court orders through himself and at his direction. And I believe that, in addition, I believe that his absence from this court today is further evidence of, I suppose, his inability to follow the court's order. If Mr. Warner would have been released and we wouldn't have any of these issues, if literally new information about other vehicles that are owned by the estate or in part by the estate wasn't surfacing within the last week, I would probably have a different position. Is it unfortunate for Mr. Warner that he may have to go back and serve those 8 days? Sure, it might be. But it's also unfortunate that he literally cannot help himself from violating these court's orders over and over again. So I'm asking that he be remitted back to jail, that he be ordered to serve those other 8 days. That I would ask that there's a finding that this is not an amendment of a sentence, that it's just carrying out of a valid sentence. And maybe by not ordering him back, that would be an amendment of your sentence. And because there's an appeal filed, we can't do that. So I think your only option, Judge, is to remand him back to the jail. Thank you.
Yes, Your Honor. I also agree with Mr. McFarland. I agree with Ms. Berger as well. I also looked and tried to find case law and other law that would be on point here as far as the stay, given the fact that the motion for reconsideration was filed, gives the court an opportunity to correct or change or do anything that it wants to do, and then an appeal gets filed later. So I was thinking that no, it would not be stayed in that circumstance because the court's going to have to rule on the motion. I defer with Ms. Berger to your Honor's judgment, and you'll know what to do on whether or not Mr. Warner should go back for 8 days. On behalf of Angelina Warner, I have to say that no, he should not go back. She was delighted to have him home. She was surprised, as we all are, because she wasn't expecting him for another 8 days. But she just really, it'd be very hard on her, devastating, judging by her reaction to seeing him when she came home that day. It would just be extremely upsetting for her, for him to go back for 8 days. That said, I leave it to the court's discretion. defer to the court's judgment. Thank you.
I think Mr. Hilderman, did you want to,
Yes, Your Honor. I'm actually in the courthouse parking lot. I was able to make it here, but I would agree with what Mr. McFarland has said as far as this not being an amendment of the court's order. It would be actually just carrying out what the court had already ordered. And on this issue with the Court of Appeals having jurisdiction, MCL 600.308 provides that the Court of Appeals has jurisdiction of all final orders. The fact that the motion for reconsideration is still pending means that there is not a final order of the court at this time. So I would submit to the court that there's actually not a stay on this proceeding today, and the court should enforce its order. The fact that someone was released early does not negate a valid order of the court. And I guess if the court is still concerned about that issue, I think we should have a chance to respond in writing to these cases that Mr. Head has cited. I don't know that.
Then comes the moment everyone has been waiting for. Although the judge acknowledges that additional jail time should have been served, he carefully weighs liberty interests.
Many of them are directly on point or speak to criminal contempt, which is a violation of the court's order and affront to the dignity of the court. And the court has the ability to ensure that its orders are enforced and carried out. So in short, there is no stay. This court has the jurisdiction and authority to enforce its orders. There's nothing cruel and unusual about the Lenawee County Jail. That's not what's before the court today. And it's certainly not an amendment of this court's order. As Ms. Berger said, if in fact the time were shortened, that would be an amendment rather than enforcing it as written.
thank you. Go ahead.
Thank you, Your Honor. With all due respect to Mr. Polderman, there is actually a court rule directly on point. And that's MCR 7.208. That's the authority of court or tribunal appealed from. And that says limitations, subsection A. After a claim of appeal is filed or leave to appeal is granted, the trial court or tribunal may not set aside or amend the judgment or order appealed from, except by order of the Court of Appeals or by stipulation of the parties. So there's also criminal contempt is a crime, and therefore an order finding a party in criminal contempt of court and sanctioning the party is a final order from which a contender may appeal as of right. And that's in Ray Maroon 295 Mishaft 312 from 2012. So this, because there's been a claim of appeal filed from a final order, it's very clear that a judgment of contempt is a final order. And because we have moved to withdraw the motion for reconsideration, even if the motion for reconsideration were to somehow render a final order not a final order, which is not the case, but even if it did, we've moved the court to withdraw. But that's not what the court is going to do. I understand the court's going to issue a ruling anyhow denying it. Regardless, that order is going to be entered one way or another. And the claim of appeal has been filed, and therefore this court no longer has jurisdiction to do anything with respect to that order, especially when that the statutory is in place. The issue that this court may have with respect to Mr. Warner not serving what this court believes was his full sentence is between this court and the jail. It is not between this court and Mr. Warner at this juncture. He was out for not a full 9 days prior to the claim of appeal being filed. And after that, now he's been out for a full 15 days. So he should receive the credit for that he deserves under the doctrine of erroneous time and liberty, which is recognized by the state of Michigan and People v. Lewandowski, as I cited. And for all the reasons I've otherwise said. The other issue is with respect to what Ms. Wilhelm indicated. It would be detrimental, it would have collateral effects to the Warner family, especially young Angelina. And it's certainly not fair to her that the jail decided to, in this court's view, release Mr. Warner early. This court knows from collateral proceedings, from other proceedings, the detrimental impact that Mr. Warner's incarceration had on Angelina, as was previously expressed in the minor guardianship case from her counselors, from the guardian ad litem, from the Department of Health and Human Services. So if this court were so inclined to believe that it does have the authority to reincarcerate Mr. Warner, I hope that this court would take that into account and consider the overwhelming and overriding collateral consequences of such a ruling. But again, for all the reasons I've stated, I don't believe, with all due respect, that this court has that authority at this juncture. I would be remiss not to mention, while I was not here for the prior proceedings, Mr. Warner was jailed for violating a civil court order. He was not jailed for a violent offense. He was not jailed for assault or a domestic assault or a battery or some type of a violent crime, some type of a drug crime, some type of a crime with a victim. There was not that type of an issue here. And while I was not present for those prior proceedings, and forgive me, I know that I don't know the entire history, it's surprising to me, because I do practice in criminal defense, that Mr. Warner was jailed for such a length of time, when I have seen, even just today, numerous dozens of criminal defendants that are charged with violent crimes that are sentenced to less. Just the court using its equitable powers, I would hope, would factor that in if the court does believe that it does have the authority to reincarcerate Mr. Warner at this juncture as well. Thank you.
All right, as it relates to the request to stay, I appreciate you bringing to the attention of the court MCR 7.208 because it does clarify, I think, in part, some of the decisions that are being submitted to the court today. For example, subsection D indicating probate actions, that the probate court retains continuing jurisdiction to decide other matters pertaining to the proceeding from which an appeal was filed. There is no amendment to the opinion that the court previously ordered. This is properly considered certainly something that pertains to the proceedings from which the
courtroom falls silent as the ruling arrives. The judge decides not to send the defendant back to jail. Instead, he closes the chapter on the release error.
Appeal was filed, but is not addressed in any way, shape, or form by the record. The court is also allowed to look at defects in the record under subsection C. There's also the fact that this motion for reconsideration really concerns the appeal. It has not been addressed, which would mean that we do have effectively an incomplete record for the Court of Appeals to review. And it does raise issues that will be addressed by the court in part, and those will be obviously very important for the Court of Appeals to consider. So for all those reasons, the court does have the authority to rule on the issues that have arisen today, including, of course, on the request for stay, which is denied. I do not think in this particular action, especially where we have the litany of examples of disregard for the court's authority by Mr. Warner up to this point, and apparently potentially continuing, that it's appropriate to allow the proceedings to stay that creates an unreasonable barrier for those that have been appointed as conservator and attorneys to be able to properly adhere to their fiduciary and legal obligations to the estate and those that they represent. Further find that the ruling on the motion for reconsideration is appropriate to complete the record and to make a decision on the error that was made in calculation of the credit that was given to Mr. Moore. I'm not going to reincarcerate Mr. Warner. Part of the beauty, I believe, in living in the United States of America is that we do have the opportunity to look at issues of liberty, and when in doubt, we should look at them in the most civilized way as possible. In this particular situation, he certainly should have had that additional 8 days. He may, in fact, be subject to the court's proceedings again in the future, according to what I'm hearing today. So on one hand, I think it's appropriate to close the door on that issue to honor the liberties that we all adhere to and uphold in our country, frankly. That was cited in many jurisdictions on the federal circuit. And so I think there's plenty of authority there. And I also don't believe that it serves the interests of Angelina Warner. And I also don't believe that it was part of the intention of the court to put Mr. Warner through another arrest booking process that was not contemplated by the original order. So we will allow him to remain outside the confines of Illinois County Jail until and unless there are issues that arise in the future. We'll close the door on that particular chapter. And finally, the court's order after the motion for reconsideration will also be issued today. And there will be an evidentiary hearing set on effectively what is the request for a Ginter hearing. So if I could ask you all to look at your schedules, I'd like to look at some dates and times for that.
I would ask for a finding of fault be placed on the jail. Specifically in your order, I'd like to preserve that for the record. I would also like to get that order in writing. I don't have a client. I've said that 100 times, she's not here. But I do know that if she were here, she would want the people responsible for letting Mr. Warner out of jail erroneously held accountable. And I don't know what will follow, but I'm asking for that written order today. Thank you.
Frankly, I don't want to say that it's simply the jail. All of us sitting here today in this room had the ability to calculate that appropriate release date and to make sure that that was communicated effectively to the jail. Asking our jail personnel to differentiate between civil contempt and criminal contempt under the same case file number was understandably out of the ordinary for them, frankly. So I think that as much as I would love to say that it is simply their fault, I think that we all sit responsible in some part for the miscalculation. And I just want to say that, frankly, I'm glad to see that the error is made on the side of liberty rather than on the side of incarceration. That's part of, again, the reason why we have the benefits of living in this country. So I appreciate your frustration and your request, Ms. Berger, but I'm going to deny it for those reasons.
Thank you, Judge.
Anything else?
That's time.
Okay, all right. So on the effectively what we're referring to as the Ginter hearing that was raised in the motion for reconsideration, I have Friday, December 22nd, or then I have to go into January. Any preferences?
I have court closed on December 22nd, Your Honor.
Great. Then I can clear that whole day. January it is. I can give you a Well, let me ask you this. How much time do you think you're gonna need, Mr. Head? How many witnesses do you anticipate?
I can think of at least 6, so we're probably gonna have, it's probably gonna be a lengthy hearing if our motion for stay pending appeal isn't granted by the Court of Appeals by that time. I think the court should at least allow the Court of Appeals that time to rule. So I think January would be more appropriate.
I would not, and that this is probably going to appear presumptuous, so I apologize to our Court of Appeals in advance. However, I have seen in other cases that for purposes of the Ginther hearing in particular, even if they granted your motion, they would be asking me to have that hearing anyway. So I would prefer to simply schedule it and get it done, rather than awaiting their directive on that point.
Understood, Your Honor.
So how about Friday, January 19th for starters?
Judge, I'm sorry, I'm out of the country.
All right, when are you back?
I'm back on that Sunday. I'm out the 18th and 19th.
I can give you a backup date on the 22nd, 23rd. And give you those 2 days as a backup to a bench trial. Is everyone clear on those 2 days?
I am.
That works for me, Your Honor.
All right, so
I am, Your Honor, I do have a pretrial, but it is at 8 o'clock in the morning on the 23rd. That should be over now.
so if we start at 9, would that
That
accommodate
would
that?
be fine. I'm sure I'll be finished by then.
All right, very good. So we'll start at 9 a.m. each day, January 22nd and 23rd. I would ask that, your witness and exhibit list be filed by the end of the year. Should be easy to remember, so that we can have a look at that and determine whether or not that's gonna be enough time. Previous to that, are you available for a pretrial conference on that on Friday, January 12th at 9?
Yes, Your Honor.
What's the time on the 22nd, Your Honor?
9 a.m. each day.
Thank you.
9, 9, and 9. The 12th, 22nd, and 23rd is what I'm suggesting.
Yes, the 12th, January 12th does work for me too, Your Honor.
At what time are you considering on the 12th, Your Honor?
9 a.m.
I'm available.
Any other questions? All right. Thank you all for your time and your hard work on this case.
As the hearing concludes, the judge emphasizes that mistakes happen throughout the process and should not be placed solely on one party. Future proceedings are scheduled, but for now, the immediate threat of reincarceration is officially off the table.